and thank you very much for joining the BMA Law series of BMA Law Legal Services for BMA members series of talks. So welcome and thank you very much for joining us today. My name is Clayton Williams. I'm a consultant solicitor with BMA Law. I've been in practice for some 25 years, specialising primarily in criminal, regulatory, coroner's inquest and workplace investigation cases. From the outset, if you have any questions at all in relation to any aspect of this today, if you could email me at c.williams@bmalaw.co.uk. So that's c.williams@bmalaw.co.uk, and we'll answer as many of those questions as we possibly can. If I can't get round to them in the hour's meeting, then I will happily respond to you once the meeting has concluded. So I hope that assists you. Just to give you a little bit of an idea of BMA Law, we offer legal services to BMA members, so it's a very warm welcome to you. If you could move the slide on, Chris, to the welcome to BMA Law slide, please. The next one again. Thank you. Thank you very much. So just by way of background, BMA Law was set up as an independent law firm. It was established by the BMA, and we offer expert and cost-effective legal advice across a number of areas of law. We operate on a not-for-profit basis so that we reinvest any profits back into services for doctors at the BMA. There was a feeling that doctors required additional services to those already covered within their member services, and we offer a plethora of and a suite of services which you are very welcome to offer, very welcome to access as BMA members. So if you want any further information regarding the suite of services that BMA Law offers, do contact me. As I say, I'll just give you my email one more time, just in case you didn't pick it up. It's c.williams@bmalaw.co.uk. If we could go on to the next slide, please, Chris. So my talk today involves the General Medical Council and the Medical Practitioners Tribunal cases. I'm predominantly a regulatory lawyer representing BMA members throughout the United Kingdom when they have to appear before the MPTS, or if the GMC begin an investigation into their practice. And as you're probably aware, in terms of being professionals, that can be a whole range of matters that aren't necessarily of a clinical nature, but they can be matters that arise within your own lives outside of work. And ultimately, as human beings, we all make errors and mistakes in our lives, and so the range of cases that come before us is enormous. It covers students through to GPs, through to surgeons, through to retired members. So the service is from, I wouldn't quite say cradle to grave, but the service extends right throughout your career as a doctor. And as I say, it can be conduct matters that appear outside of your clinical practice. So, for example, we have students who may get arrested in a foreign jurisdiction. We have cases that involve domestic incidents that happen in people's home lives. We have driving offences, notably drink driving offences, but they can be far more complex cases which involve death by careless driving or death by dangerous driving, and then all manner of cases that fall foul of clinical expectations of doctors. So I appreciate that it's not perhaps necessarily the most cheeriest of debates today, but I just want to reiterate the fact that it's highly important that the first thing you do if the GMC does contact you for any reason is to reach out straight away to your one of your defence organisations. Obviously, I'm here on behalf of BMA Law, but there are, of course, other defence organisations such as the Medical Protection Society, the Medical Defence Union, for which your membership may assist you in relation to that matter. I think one of the takeaways of today's talk is to ensure that if you're ever contacted by the GMC, that it's extremely important that you reach out to your defence organisation, who can provide specialist help and assistance in respect of these matters. So if we just go on, so that's by way of introduction. If we can go on to the process now, please, Chris, which is slide 6. Thank you very much. So in terms of an investigation by the GMC, I think the important point to make is that probably 50% of cases that are investigated by the GMC do not necessarily go to the medical practitioners tribunal. They could be resolved by way, for example, of a warning. So a good example of that would be lots of cases that involve more minor criminal offences, such as drink driving. That's not to take away from the seriousness of the case, but those matters that are deemed to be more low level, where, for example, nobody's been injured and that the alcohol readings are low, that often, for example, will result in a warning. Other conduct cases involving perhaps your family, or an altercation that a doctor may have on an evening out. These are the type of cases we see. These are matters that quite frequently will get resolved by way of a warning. But of course, the decision as to whether to proceed in a case is taken by the GMC case examiners, and clearly the more serious matters, which involve perhaps data protection or a breach of GDPR, or whether there are serious clinical concerns, or most significantly where there's also an element of dishonesty, they almost always are cases that would eventually appear before the medical practitioners tribunals. So it's very important to deal with these matters early on, as I say, to ensure that you have representation, because you will have an opportunity to respond to the allegation very early on in the process, and your views and representations will be considered by the case handlers in order to make a decision in your case. So it's extremely vital that you take action very, very quickly, because the faster you act in these cases, the sooner they'll come to a conclusion. So in terms of the GMC process, you'll be first of all asked to provide the GMC with details of where you're working at the material time. You'll also be asked to give a précis of where you have worked. The GMC will investigate the case, whatever it might be, against you, and then they'll give you an opportunity to comment on the allegations, if any, before the case examiner makes a decision. If that decision then is to refer your case to the medical practitioners tribunal, that then is a separate process. Although they are part of the same organisation, they work independently of each other. So the medical practitioners tribunal process will begin, and it's a reasonably lengthy process. The only good thing about it, I have to say, is that the MPTS continued right throughout the pandemic. There's a large number of courts within the tribunal in Manchester, so cases do get moved on quite quickly. They're a pretty organised group, and I have to say, generally, we as lawyers were quite impressed by the way in which they handle cases that come before them. But clearly it's a difficult and emotional process for doctors, and of course you might have third-party agencies involved in your cases, which I'll come on to in a moment. So in terms of procedure at the MPTS, your lawyer or your defence organisation will assist you with that process and what is required of you. We will, when representing doctors, prepare a statement that can be put to the GMC in response to the allegations. If the allegations are not denied, then we make admissions as early as practicable. And what then happens, of course, is that within the Medical Practitioners Tribunal, there's 3 stages of the process. The first is to deal, if you like, with the allegations. The second part is to then decide whether or not the individual practitioner's practice is impaired in some way, the fitness to practice is impaired. And if they decide that your fitness to practice is in some way impaired, then they will consider sanction, which, as you probably are aware, can range from the warning that we've discussed, which is normally offered in advance of MPTS proceedings, through to conditions, suspension, or the sort of most serious sanction is of erasure, which is obviously used within the most serious of cases. As a rule, cases that come before the MPTS are within 5 years. They don't particularly like going outside of that, although there is provision that they can do. So it's normally cases that are reported within a 5-year period from the date of the incident. So in terms then of what you need to do, Chris, if I could get on to the next slide, please, slide number 7. Don't know if he's there. Yes, thank you, Chris. So in terms of your response to the GMC, both the GMC and the tribunal, what is significant and what is unusual really as a lawyer or people approaching these type of cases is that in most other arenas of the legal profession, in terms of the court, in terms of the tribunal, you're often defending a case, whether it be in the criminal court or the employment tribunal. You're often either, in terms of the tribunal, bringing a claim against your employer or you're defending your own actions. So the concept of the Medical Practitioners Tribunal is entirely different, because what they're interested in is the response from the individual doctor. And I have to say that if, for example, the case against you is strong and if you accept the case against you, it's important that we do so at the earliest opportunity, because what the tribunal is ultimately concerned with is, are you fit and proper to remain in practice? And their primary overriding objective is the protection of patients. So it's highly important that if an individual practitioner has done wrong in some way, as I say, we are all human beings, then it's important to make admissions at the earliest opportunity. And then what they are interested in then is, in a sense, you turning yourself inside out into looking at yourself, looking at your behavior that's caused the incident in the first place, demonstrating remorse, showing insight, which should be by way of attending courses in relation to good medical practice or good conduct as doctors, and to present yourself as somebody who has remediated from the original offence, if you like, that you're before the tribunal for. So these things are, they're quite nuanced. It's important as well that, you know, the tribunal has to be satisfied that these are genuine reflections and genuine remorse, and you know, quite a lot of work needs to be done in respect of that, and it will soon become clear to both the GMC and the tribunal if, for example, they feel that that remediation in some way isn't genuine. So it does take a lot of work. It does take a lot of commitment from the individual practitioner to ensure that they absolutely you know, take the advice from their representative. So I'm just keeping an eye on emails that are coming through, so I'll respond to those a bit later as we go through the presentation, if that's okay, but they are coming through. So Chris, if we could go on to slide number 8, please, the preparation of a statement. Thank you very much. So we will have time. Again, I have to say that my experience of the GMC and MPTS is reasonable in terms of timescale. That they're not overly draconian in their flexibility. They do allow practitioners to have plenty of time in order to prepare their case. So it's not always good to respond at the earliest opportunity. I just want to make that point clear, because if the GMC case is thin or weak, then there's no advantage in making any comment until we are satisfied that the GMC wish to bring a case against you. A very good example of that is often the GMC, unfortunately, is being used more and more in domestic situations, divorces between warring partners, and it is very sad, actually, that the regulator is being brought into such cases. So, for example, if one party to a marriage or relationship is a doctor, then quite often another partner will see it as part and parcel of the divorce or family proceedings. So we're seeing that more and more, where the GMC is being brought into those processes, some legitimately, of course. I think where there are concerns about somebody's behaviour, of course, it's only right and proper that the GMC are informed, because, of course, if for example, there's an accusation of violence or something more, something more sinister in terms of sexual allegations, then of course that has to be brought to the attention of the GMC. So, but there's an example in so many of these cases that actually we have situations where people no longer want to pursue family proceedings, relationships repair, and so you find that one has to gauge how advice is given out in relation to GMC proceedings. It's better sometimes to allow things to run their course to see if any allegations or charges do come about from the GMC. So that again is something that you will be carefully advised on in relation to whether or not we provide a statement. Once the decision is made that there are to be charges, then of course we have a discussion as to whether those are accepted or whether those are denied. And I don't want you to come away from this talk today thinking that you accept everything, because that isn't the case at all. If you say to us or to your defence organisation, well, these things are simply untrue, it did not happen, then of course we defend the allegations, and it will be our opportunity in the statement to respond to those charges and to include all information that defends those particular allegations. If, however, we are accepting what's being said against us, then the statement really is a preparation in mitigation and remediation, and to show that absolutely we accept what we've done, whatever that might be, whether it be clinical or something from outside of your workplace, but we do so on the basis that we show real development and learning in terms of courses that have been undertaken, not only those that relate to conduct, but if it's a clinical issue, we would need to show some reskilling and real attention to the concerns that have been raised about one's clinical skills. Chris, if I can go on to slide 9, please, regarding witness evidence in support of the individual practitioner. So I have to say, in my experience, the MPTS and GMC do like to see supportive witness evidence from responsible officers, clinical leads, supervisors. We can add in references from friends or family or co-workers, people who perhaps know you in a non-clinical setting. But I have to say the most persuasive and significant evidence, certainly in my view, is evidence from those who supervise you in the workplace, particularly, of course, if it's a case involving clinical concerns. So it's a good thing to reach out to people early on in the proceedings. You are, of course, under an obligation to inform the GMC if there is an allegation against you, or if there are concerns outside of your workplace. It doesn't extend to, for example, very minor driving offences such as speeding or a low-level due care, but virtually everything else, it's better really to inform the regulator, because the absence of doing so is, of course, a separate regulatory offence in itself. So it's very important that you liaise with the GMC immediately, and if you have any concerns as to whether it should be reported or not, then obviously speak to the BMA or your defence organisation. I mean, quite often, if it's a workplace matter and you're, for example, suspended by the employer, then that will happen anyway. So that's just some advice in relation to who make good witnesses. One thing I would say is that in terms of supportive witness statements, the mantra really is less is more, and so you want good quality statements from responsible officers, not a cast of thousands. It's better to have a few references of high quality, because that will have a greater impact on the tribunal. So that's just a discussion around witness evidence in support of you as individuals. So I don't know if Chris is there, but I'm going on to slide 10 now, which is to do with, thank you, Chris, to do with outcomes. So as I mentioned to you, it really depends on how your case is run. So, for example, if the case is being challenged, if you don't agree, for example, with the allegations that are put against you, we have to challenge those. And so that's the first stage of the medical practitioners tribunal. If they then determine that, yes, the allegations against you are found, then they have to decide on impairment. If, however, we've agreed the charges in advance, the whole process is shortened considerably, and we go straight into whether or not you, by virtue of your behaviour, are you impaired. If the decision then, which is given lengthy consideration, if it's determined that you are impaired, your fitness to practice is impaired, the final stage is then in relation to sanctions. And there is a number of options available to the tribunal, as I've mentioned, from conditions upon your practice to a suspension for a period of time or erasure. So these are all appealable to the High Court. That there is always a concern about appealing cases to the High Court, because one could argue it doesn't really show much insight if you're appealing a sanction. But having said that, if it is inequitable and wrong in law, then of course in those circumstances an appeal may be necessary. Just on that point in respect of costs, you know, which I will come on to, but if you appeal to the High Court and you're unsuccessful in challenging the decision of the MPTS, you run the risk of not only paying your own costs, but also the costs of the tribunal itself. So you always have to have very careful and specialist advice in relation to any appeal. So if I can go on to 11, please, Chris, which I've dealt with very briefly about the appeals process in the High Court. Just in terms of costing, you will need to check with your defence organisation whether your costs are covered in relation to your tribunal claim. I know that, for example, some of the defence organisations have very specific rules about what type of proceedings you're covered for. So, for example, if it's a clinical matter, then often you are covered. But if it's something non-clinical, if it's, for example, if it's arising from something in the criminal or in the family courts, because it's outside of your workplace, there may be a reluctance to support your case. So I just need to make you aware of that. And just on that point, I think it's always good to refresh one's indemnity and insurance policies, and this might be an opportunity for individual practitioners to have a look really at what you're covered for by your defence organisation or by your BMA member services. I think it's healthy really to have a refresh, even have a look at your own professional indemnity or even your home insurance, because you can never be over-insured is my view about these type of cases. So just going on then, Chris, to slide 12, which relates to support. We've mentioned, of course, trade unions and defence organisations. They then in turn will instruct lawyers to assist you at the tribunal and advise you on, give you advice on the best way to deal with the case, the specific case against you. I think it's always important as well to have counselling during the process, because quite often doctors are facing not only a claim in the tribunal, but they're also potentially involved in a criminal case. They could even be involved in family proceedings. So, for example, if somebody, is going through an acrimonious breakup and there's allegations of violence or other allegations, in that type of scenario, the individual practitioner could be suspended from work. They could be fighting to have access to their children. They could be facing proceedings in the criminal court. So it's very, very troubling and a very bleak time for people. So it's essential, in my view, that counselling services are accessed. And from our experience, those who do access those services do seem to recover far more quickly than those perhaps who feel that they can go it alone. So it is essential that you access all of that support. And if the charges against you are of a criminal nature, it's essential that you have a solicitor representing you in the criminal courts or at the police station, which is often the most important part of a criminal case, because what you say or don't say in the police station can very much affect the rest of your criminal proceedings. So absolutely have representation in the police station. If for any reason you are arrested without any notice, you are entitled to have free and independent legal advice in the police station. It's not means tested. It's available from the duty solicitor scheme, and just to sort of debunk any myth around the duty solicitor scheme, they are solicitors within a catchment area who run private firms, nearly all private firms. There is a public defender scheme as well, but these firms will be very experienced in criminal law, and they will be able to assist you if for any reason you can't get hold of your defence organisation. For example, if it's an arrest in the middle of the night, you do need support very, very quickly, and they will help you through that process. And I think what is important about that point is that what happens obviously in any criminal proceedings could have a very serious impact on your ability to practice as a doctor. So it is crucial in those proceedings that you have assistance and representation to put you in the best place possible for any medical practitioner's tribunal claim. So in addition to that, you might have a suspension from work. It's absolutely critical, of course, that your employer is made aware if there's any allegation against you. Obviously, if it's in a clinical setting, they're probably going to be aware of it before you. But if it's something arising outside of work, there's an obligation on you to inform your employer. There's an obligation on you to inform the GMC. So it's all about protecting yourself and advancing your position. That, again, it can be difficult because the employer may feel it has no choice but to suspend you, which is a neutral act to protect both parties. They may, however, feel that they can work with the allegation or complaint by imposing conditions within the workplace. I always encourage employers to do that, because when doctors are going through a number of challenges in terms of the proceedings that they might be facing, it's always better to try and keep people in work. Obviously, in certain cases, that would be impossible if they were extremely serious allegations. But where the employer feel that they can keep somebody within the workplace by attaching conditions on their work, I always encourage that. And often, for example, employers will be happy to impose the same conditions as maybe the police have done so in bail conditions. I've seen that happen. So, I don't want you to go away from this feeling, that all is lost, because it's not. But the key really is to be absolutely transparent in your dealings with the employer, with the police, with the family courts, and with any other agency who might be involved in your case. So, as I say, the cases that come to us, they are all unique, and it's absolutely critical that in order to get help and support throughout those proceedings, that you contact somebody to help you. Don't try and go this alone, because similarly to the medical profession, the legal profession has its own peculiarities and rules, and you're going to need support in relation to that. So I hope that's a sort of a whistle-stop tour of the MPTS and the GMC and some of the associated third parties who get involved with some of those cases. So what I'll do now, I'm just going to have a look through the emails that I've received. So, yeah, one doctor has commented about concerns regarding the GMC failure to disclose evidence in totality. I mean, certainly in terms of the GMC, they are, if you like, a de facto prosecutor. Their job really is to build the case against the individual. Case examiners and lawyers within the GMC will take a pragmatic approach in terms of what allegations should be charged, to the individual practitioner. It doesn't mean that they're going to throw everything at the practitioner. They will often, choose charges that they feel are the most pertinent. So, but I share your point, Doctor, that, of course, ultimately the GMC role, as I say, it is a de facto prosecutor. They're bringing the case against you. So it's our job as your representative to ensure that, we absolutely put forward your defence to any allegations. So, but please do reach out always to your representatives who can assist you in making sure that those allegations are properly responded to. The other point worth making about MPTS proceedings is that we may have a charge sheet of perhaps 10 charges, but we only accept half of them, and that our view is that we challenge the rest. But sometimes the GMC may take a view then on the totality of the case. There is an obligation on them, just like a prosecutor, to review any new evidence that comes to light. And so don't feel that once you're in the process, it's necessarily going to follow its way through all the way to a tribunal case, because that isn't necessarily the case. So, as I say, it's not not getting away from the fact it's a pretty traumatic experience when one is faced with any sort of allegation or complaint, and because of the various agencies involved, there needs to be a discussion with employment lawyers, through member services of the BMA. There may be a disciplinary or investigation running within your employment that's going to result in a disciplinary. I think that there are conversations around that can be had, and whether or not that there's some mutual benefit in the practitioner leaving a trust or a GP surgery under their own terms. So those are conversations that should be taking place as well. it's not, doesn't necessarily follow that, that might be on offer. It might not be the gift of an employer to do that. But there's another aspect to this. So when you're involved in a GMC case, it then involves, so many other groups, whether it be the employer, well, almost certainly the employer, but also the police and family courts that I've already discussed. So you might find that, in certain cases that you have 3 or 4 different people representing you for each part of the case. So, it is stressful and stressful for your families as well. And that's why there are services available. There's services through the BMA, I'm sure through other defence organisations that you can access to make sure that you're provided with support, emotional support, and legal support too. So, not an easy period for people going through these processes. But I suppose the advice I always give is that whilst it's pretty awful at the time, we've represented thousands of doctors who have come through the other end. It makes them a better practitioner. And as I say, we are ultimately human. We have bumps in the road, but at some point it will be behind you, and you can move on as a better and more seasoned practitioner. I'm not getting away from the fact that there are people who whose cases are so serious that it renders their career expunged, but in statistical terms they are few and far between. Most cases that come before the MPTS, I would say in our experience, probably over 90% of those cases are resolved in some other way, some lesser sanction. So I don't want to, I want to give hope as well in this conversation that as long as you are being properly advised and you're accessing advice early on, then my view is that you do everything to put yourself in a strong position with the GMC and with the tribunal, who I've got to say, I know people wouldn't necessarily agree with my view, but my own experience of dealing with them is generally quite favourable. I know that there are inevitably horror stories as well about these procedures, but it's all about managing them very, very early on. So I hope that does assist in giving you some guidance for GMC proceedings, how you should deal with them. I think that the sound advice really is not to do it on your own. Get help and support. That's what we're here for. That's what we're trained and experienced to do, and to do everything we can to resolve these cases as quickly as possible for you, and to put you in contact with third parties should you need further assistance. So you're not alone in these cases. It can be very distressing when you first hear from the GMC, but as I say, in 9 times out of 10 cases, they are matters that can be resolved where there is no lasting or long-term damage to the individual practitioner's career. So as I say, I'm very grateful. I noticed we're sort of coming up to about 1:45. So I think that by all means, do contact me if you have any questions that arise from this talk about the GMC or the MPTS, or indeed any matter related to that, whether you find yourself in police stations, the criminal courts, or employment, disciplinary or investigation cases, then I can assist you and signpost you as best I can. But yeah, very happy to have that conversation. My email address again is c.williams@bmalaw.co.uk. So the BMA Law is one word. So c.williams@bmalaw.co.uk. So I appreciate that was a whistle stop tour of GMC and MPTS proceedings and the ancillary third-party cases that can arise. So just before I I've just had an email come through actually, so let me just have a look at that because it might be something interesting for the whole group. I aim to round off at 1:45, so if there's anybody else who wants to speak to me yeah, about this. Yeah, in terms of criminal proceedings, somebody just asked me about the criminal proceedings. In terms of funding, again, it depends really on what you're facing. So you would have to, again, check with your medical organisation or your indemnity insurance about whether you're covered for proceedings in the criminal courts, just so that you're aware. Police stations is the one area of proceedings which are still free. If you want to rely on one of the excellent legal aid lawyers that practice around the country, so that process will be free. The only issue I would raise, of course, is that we would encourage you to go to your medical defence organisation because, to be clear, we want to ensure that those people representing you understand what might happen to your career. So, for example, it might be very tempting to accept a caution in a case, a police caution, but that may have implications for you later on. I think I've given an example before in this talk where we, in a previous job, I represented the education unions, and one headmaster went into, head teacher went into a supermarket with her 3 young children, and unbeknownst to her, left the supermarket without paying for a bag of shopping that was hanging on the back of her trolley. She paid for everything else within the trolley, but the police were called, and I think given that she was in such a state with 3 young children and really anxious, she accepted a resolution to that, which was essentially signing that she had committed an offence. And when she then went for a new job some years later, it appeared on her the enhanced check of her DPS. So that's something to be conscious of. That yes, if you have to, for example, if you're sort of woken up in the middle of the night by the police, hopefully not, and you can't get hold of a defence organisation, and you want you use the judicial solicitor, which I would encourage you to do. It's just important to understand that anything that goes on within the criminal proceedings, will have an effect on your job. So you just need to be very cautious of that and very mindful of that, and perhaps speak to your medical defence organisation before you make any decision on what to do in the criminal case. In terms of funding in the higher courts, there is a legal aid scheme that's still running, but it's more and more difficult now to obtain state funding. And you may need to make a contribution to your costs. So again, that is all something that can be discussed. It might be that your defence organisation will support you in that case, particularly if it's a clinical matter that's arisen, which results in you going to the criminal courts. And just on that point, the other issue, the other cases that we get asked a lot about is the coroner's court. Lots of doctors are called to give statements to the coroner's court. They're nearly always represented by the trust, the individual trust. But I think just to be cautious about that your evidence may not chime with the position of the trust, and you may need separate representation. So again, that's something to check with your defence organisations and your own indemnity or insurance policies, because you could be called as an interested party to a coroner's inquest, and that's something again which we can provide advice and assistance on, particularly where your position, as I say, may conflict with the decision of the trust. So that's just to make you aware as well. Again, I mean, it's such a huge industry, medicine, that no 2 cases are the same. As I say, it can be anything from students in medicine to GP partnership disputes and all of the issues that arise out of that, which can include the regulator, it can include the employment tribunal, So it's complex, right the way through to hospital trusts, those who work in the private sector. There's an awful lot of implications, particularly now in terms of the devolved nature of the country, with NHS England and the CQC and the differences in Wales and Scotland and Northern Ireland. So it's the enormity of it means that it's absolutely critical that you ensure that you are properly protected and properly advised. So I hope that gives you some assistance. I've just got one last question that I've been asked about warnings. One of your colleagues has asked how long do warnings last? Well, warnings last for 2 years. They remain on your public register for 1 year. And then after that time, they'll fall off. So, but look, if you've got any specific questions, do not hesitate to contact me. We're just slightly over our time, so I'll leave you have some time for lunch and a cup of tea. And thank you very much for joining our talk today. And do not hesitate to contact BMA Law should you have any questions in relation to this rather complex area. But as I say, that's what we're here for. That's what your medical defence organisations are here for, to protect you and protect your interests as doctors. So thank you very much. I'm a Welshman, so diolch yn fawr, and you take care and good luck with your continued professional work. Thank you very much.